Tęsėme mūsų
So let us continue our conference. And on our agenda, we have next speaker, member of the European Parliament, former chairman of the Lithuanian Constitutional Court, Professor Dainius Žalimas. I invite him to give his presentation. Thank you very much, dear President of the Lithuanian Chamber of Notaries, colleagues, guests of this conference. Я хочу особисто congratulate and welcome our Ukrainian colleagues. So today I'm going to speak on the rule of law imperative as raison d'être of notarial activity. So I'll be talking about things that are common to both countries. And despite the differences we have in our constitutional text, and I think that the constitution of Ukraine is more detailed compared to Lithuanian constitution, but the general principles apply. They're not subject to change and their content is rather universal in my opinion. So what I'm going to talk about maybe relates more to the Lithuanian side, but I think some things will apply in particular when it comes to the notary profession in Ukraine from the perspective of the Ukrainian perspective. As you know, so far the Constitutional Court has directly analyzed the status of notaries only once, in 2010. This constitutional justice case created preconditions for the Constitutional Court to disclose for the first time the significance of the profession of notary, the model of notariat operating in Lithuania, and the fundamental principles of regulation of notary's activity deriving from the Constitution. First of all, we can see from this judgment the relationship between notariat and the rule of law. These two seem to be very different, but when you look into detail, we come to a different conclusion. The Constitutional Court has emphasized that the notarial profession is entrusted with public interest functions. They must ensure that the civil legal relations are free from unlawful transactions and documents. More broadly speaking, this means that the notarial profession performs an important preventive function in the legal system. Through their actions, notaries must contribute to ensuring that the rule of law prevails in the state, that its rule is not threatened, and the participants in legal relations can have confidence in law and the state. And this is the essence of the principle of the rule of law, many times discussed and enshrined in the decisions of the Constitutional Court. Let us recall that, as the Constitutional Court of Lithuania has pointed out, the imperative of the rule of law means that the law must be obeyed by all subjects of legal relations. And I stress this, all. The rule of law is the essence of the constitutional principle of the rule of law. This principle is universal. It underpins the entire Lithuanian legal system and the constitution itself. It must be followed both in the creation of law and its in implementation. Therefore, no one, neither public nor private, what's relevant to notaries, actors in legal relations, are immune from the operation of this principle. All of this suggests that the significance of the rule of law imperative for the notarial profession is twofold. Firstly, this imperative is a constitutional landmark in the professional activities of notaries, which they must protect. And second, the constitutional principle of the rule of law is a measure of the evaluation of the professional activity of notaries themselves. This is also reflected in the basic acts regulating the activities of the Notariat. Before taking office, a notary must take an oath to be loyal to the Republic of Lithuania, to observe its constitution and laws. Notaries are obliged to be guided by the Constitution of the Republic of Lithuania, laws and other legal acts in their activities. Notaries exercise their powers independently of the influence of public authorities and administrations and are subject only to the law. And I don't want you to understand law very literally, but I'm talking here about the constitutional law. Finally, notaries are obliged to refuse to perform a notarial act if the performance of such an act is contrary to the law and does not comply with its requirements. Notaries are also obliged to inform competent state authorities about possible violations of law detected in the course of their professional duties. And the Code of Ethics of Notaries of the Republic of Lithuania says that very explicitly, that the notary acts as a public trustee, and with their actions, they contribute to the creation of the rule of law. As you know, the rule of law is a multifaceted constitutional category, inseparable from the aspiration for an open, just, and cohesive civil society. It integrates many different and interrelated requirements: the protection of individual rights and freedoms, as well as the protection of legitimate expectations, legal certainty, and legal security are integral elements of the constitutional principle of the rule of law. As the Constitutional Court of Lithuania has repeatedly pointed out, they imply the obligations of the state to ensure the certainty and stability of legal regulation, to protect the rights of individuals, to respect legitimate interests and legitimate expectations, and to fulfill the obligations assumed by the individual. In this context, the state's duty is to ensure the certainty not only of legal relations, but of all legal relations in general should be emphasized. Failure to do so would undermine a person's confidence in the state and the law. A more detailed look at the functions entrusted to notaries by the state shows that notaries are entrusted with the right to legally establish undisputed subjective rights and legal facts of natural legal persons. Notaries exercise this right by performing a wide range of notarial acts, such as attesting the authenticity of documents, authenticating the records contained there, certifying documents and transactions, attesting facts, accepting official documents. As mentioned above, if the requested act is contrary to the law, the notary must refuse to perform it and report the suspected infringement to the competent authorities. It is clear that the professional activities of notaries contribute to the realization of individuals' rights and legitimate interests, enables the prevention of possible infringements of individual rights and legitimate interests, provides certainty and security in legal relations, guarantees coherence and trust between the participants in legal relations, and as a result, people's confidence in the state and the law. The Constitutional Court, in its decision of March 22, 2010, stated that in Lithuania there is a so-called Latin-type notariat. Although the Constitutional Court did not say so directly, it is obvious that the introduction of the Latin-type notariat should be treated as a constitutional imperative arising from the tradition of the democratic state of Lithuania, as expressed in the Constitution and in the Act of Restoration of Independence. It is generally known that Latin notariat is a type of notariat where a notary performs public functions delegated by the state, but organizes his or her work independently as a representative of a free profession. Here, the notary is functionally a representative of the state and financially and organizationally a private person. At the same time, notaries are constitutionally a state-controlled profession, which is understandable. The necessity of state control arises from the public nature of the functions performed by notaries. In other words, the state, having entrusted notaries with the performance of public functions, must ensure control over the manner in which those functions are performed. So the control is there. It is of a democratic nature. A systemic assessment of the official constitutional doctrine formulated in the context of the assessment of the constitutionality of compulsory membership in the Lithuanian Chamber of Bailiffs and the Chamber of Architects suggests that the most important form of such control is the self-government of the professions under the control of state. In this context, we may recall that the rule of law is inseparable from the pursuit of an open, just, and harmonious civil society, that such a society is in turn inseparable from the initiative and self-government of its members, who are organized according to their various interests and activities. According to the Constitutional Court, the self-government bodies of state-controlled professions perform public functions entrusted by the state. That is, they ensure transparency and quality control of the activities of persons of this profession. And as the Constitutional Court has pointed out, in the absence of such a system of self-regulation and self-government, the transfer to private hands of the relevant functions which the state is obliged to ensure the performance of could be constitutionally constitutionally unjustified. To sum it up, it can be stated that the functions entrusted to notaries by the state oblige them to be independent guardians of the rule of law. That is, they have to supervise and ensure that the subjects of legal relations respect and do not violate the law, and at the same time are able to enforce the indisputable rights and legitimate interests they have. So the meaning of notary's activities and their raison d'etre in this way, the notariate is one of the indispensable institutional pillars of Lithuania as a state governed by the rule of law. You, notaries, perform state functions, public functions. You ensure that law is maintained in Lithuania. I would stress that notaries are one of the strongest pillars of the rule of law, as they are traditionally one of the legal professions with the highest trust index among the population and businesses. So once again, congratulating the entire notarial community, I wish it to continue to remain in the view of the Constitution an exceptional and successful profession that performs the public functions entrusted to it by the state, and on the success on which the welfare of all of us and the success of the rule of law depends on to some extent. Thank you very much for your attention. Thank you, Professor.
Į tribūną kviečiu Ukrainos notarų rūmų prezidentą.
Now I would like to invite Vladimir Malchenko, President of the Ukrainian Chamber of Notaries, to the podium to deliver a presentation on realities and prospects of Ukrainian notariate development despite the war. Mr. President, Presidents of Notariats, dear guests, the war taught us to live in difficult conditions. As the famous saying goes, we do what we can under the existing conditions where we are. From the very beginning of the full-scale invasion of Ukraine by the Russian Federation, notaries remained a pillar of support for society. Notaries ensured the availability of notarial acts even in particularly dangerous territories, worked under fire, and preserved archives, which they continue to do so today. In the first months of the active phase of the war, by joint efforts with the Ministry of Justice of Ukraine, we managed to restore many state registers, including registers of real estate, business, inheritance, powers of attorney, and forms. Land reform is ongoing, and the land market has moved to the second stage, where Ukrainian legal entities can participate. The state has given notaries a leading role in the process of formalizing transactions. Innovations have also been implemented in the registration of newly built housing and real estate, the so-called primary development, with a large complex of protection of investors' rights have also been implemented. The state has entrusted notaries with the authority to record property damage and destruction caused by Russian aggression. Notaries perform the functions of registration of legal relations regarding compensation for destroyed housing, which gives a person the opportunity to buy his own housing with a certificate from the state. Notaries are an important element of the state policy in the field of sanctions and financial monitoring. Ukraine's Notariat continues to work effectively and retains its authority in society, ensures the activity of civil turnover and economic stability in the country to the maximum extent possible, and in times of war, it has become even more necessary for people and needs reforming even more.
Запровадження електронного нотаріату, розширення повноважень нотаріусів і поступове
The main markers of the notary reform are the transition of the profession to self-regulation, the introduction of electronic notaries, the expansion of notaries' powers, and the gradual transition to a unified notary. The concept of reforming notary system of Ukraine was developed by the Notary Chamber of Ukraine and published back in 2017, and its basic principles were subsequently transformed into draft law number 5644 on amendments to certain legislative acts of Ukraine on improving the regulation of notarial activities. It was developed jointly by the NCU, the Ministry of Justice, and other stakeholders and experts. It is important that the co-author of the draft law is People's Deputy of Ukraine, Igor Frois, a notary who temporarily stopped his activities in connection in the election to the parliament. The draft law was adopted by the parliament in the first reading as a basis on 15th of February 2022. But on the 24th of February, Russia's full-scale invasion began. All plans were suspended but not destroyed. Now we are continuing this work, and given the martial law and new challenges, the draft law has become even more relevant. So we hope for the adoption of these changes as soon as possible. The lack of modern and innovative solutions in the notary's activities makes the procedure performing notarial actions complicated, long, and hinders the development of the notary. What does the reform envisage? Expanding the powers of notaries. First of all, I would like to draw attention to an innovation that has already been implemented, notaries mediation. At the end of 2021, the law of Ukraine on mediation entered into force, according to which notaries have the right to conduct mediation, provided they have undergone basic mediator training. Such basic mediation training for notaries is provided in particularly by the Ukrainian Chamber of Notaries. In 2020, the Chamber Mediation Center was established and is actively working to develop this area. Notaries study and practice as mediators and successfully apply their skills in their daily work. But for the sake of reform and in view of the needs related to the war, it is necessary to give notaries the power to secure evidence in case the relevant means of proof may be lost, or there are reasons to believe that the provision of evidence may become impossible or difficult. It is also planned to introduce the possibility of out-of-court establishment of facts of legal significance by a notary. This proposal is also due to the fact that the notarial procedure will require less cost compared to court proceedings and is more psychologically attractive than the judicial procedure, and in combination with the notary's function as a mediator, this will give the best effect. In addition, notaries will be able to perform state registration of marriage and divorce. In order to ensure comprehensive protection of the rights of corporate entities, the principle of a one-stop shop should be provided for, that is, all transactions related to the transfer of ownership to corporate rights are subject to notarization and simultaneous registration. A number of government services can be optimized by transferring the relevant powers to notaries. In fact, it is a question of creating a kind of notary house of justice on the basis of a notary's workplace. Implementation of the electronic notary system. E-notary is something we have been talking about for many years. Of course, the use of modern technologies in the field of notarial activity is gradually becoming more and more implemented. But this issue has many nuances that need to be taken into account. The issue of introducing e-notary is important not only for notaries, in the context of simplifying document circulation, archive storage, etc., as it will primarily affect the procedure for protecting the rights of persons applying for notarial acts. The main and most difficult task in implementing e-notary in Ukraine is to ensure the safety of digital data from compromise, reliable storage of information, servers and access to them, and preventive work to protect against cybercrime. In times of war, the level of cybercrime increases tenfold, from small-scale individual interferences to specially designed operations by the aggressor state. At the same time, attacks on access to information, its distortion, destruction, and use by the aggressor state, and by cybercriminals for the purpose of material interest, are an objective circumstance that must be taken into account when building the concept of any electronic registry in Ukraine, in particular the e-notary. Among the key necessary changes is the creation of an electronic register of notarial acts and a digital notarial archive. It is worth noting that the electronic register of notarial acts, in accordance with the international standards and the practice of Latin-type notaries, is developed and implemented by a self-governing organization of notaries, which in Ukraine is the Notary Chamber. We believe that the chamber should be at least a functional administrator of such a register. The best option for the functioning of the e-notary is to coordinate the work of the electronic register of notarial acts with other electronic registers and services used in the performance of notarial acts. It is important to introduce an automated notary workplace and remote client authorization through data exchange between Ukrainian registries. Undoubtedly, the digitalization of notarial activities will allow notarial actions to be performed faster and better. At the same time, the introduction of e-notary should be approached carefully without haste, based on the best practices of UINL member notaries, but always taking into account the realities of Ukraine. We have experience of living in times of war, power outages, cyber attacks, so along with the introduction of e-notary, it is necessary to provide for parallel notarial acts in the absence of electricity, software failures, etc. That is, to provide for mechanisms that would allow notaries to work fully in such conditions. The introduction of electronic technologies into the notarial process is an integral part of the development of notaries. Only the quality, scope, and methods of application of new technologies remain open. The e-notary must reliably protect the rights of individuals and legal entities who perform transactions or apply for other notarial actions. The Ukrainian Chamber of Notaries is working on this in a thorough manner together with the Ministry of Justice of Ukraine. In terms of self-regulation of the notary profession, one of the principles of the planned reform of the notary profession in Ukraine is a gradual transition from professional self-government to self-regulation. Notaries have built a strong self-governing organization, the Notary Chamber of Ukraine, the Chamber of Notaries of Ukraine, and are therefore quite ready to take on even greater responsibility for the development of the profession on the basis of self-regulation. The Ukrainian Chamber of Notaries can receive more powers, in particular control over the organization and activities of the notary, office management, organization of professional development of notaries, approval of the Code of Professional Ethics for notaries, and control over it, observance, creation of conditions for proportional distribution of notaries' workplaces throughout the territory of Ukraine. Endowed with the appropriate powers, the Ukrainian Chamber of Notaries has a multitude of advantages for this, provides a multitude of advantages for the state society in general and the notary community. We have a duty to move away from the artificial division of notaries into public and private ones, and to establish the unified status of notaries, as has long been done in leading European countries. However, at present, the powers of private and public notaries in Ukraine are identical, so the main focus of this reform is on budget financing and the need to protect socially vulnerable groups of the population. The transition to a unified notary will involve a proper transition period and the gradual cessation of the activities of state notary offices so that this does not negatively affect either the notaries themselves or the citizens, but brings only positive changes. The Notary of Ukraine performs an important social function, is an institution of preventive justice, a body of undisputed civil jurisdiction, one of the key institutions of the state. Therefore, the quality reform of the notary with mandatory consideration of the peculiarities of Ukraine is the key to the stability of civil turnover, especially in difficult times of war. We discussed this with Marius a bit yesterday when we were preparing for this event. We received questions from colleagues from Germany, France, and other countries. We collected these questions, and if Marius allows me,
відповідати на питання.
I need some 5 or 7 minutes to answer your questions. There are two questions which
Швидко були поставлені. Перше, яку допомогу українські
were
нотаріуси
asked a
отримують
lot. The first one is what support Ukrainian notaries receive from other notariats all over the world. And the second question was what support the Ukrainian notariat needs. And this was the question from the German notariat. I did not provide this text to the interpreters. I will speak slower. From the very first days of the war, we felt huge support from different countries, including the KNU, which expressed its solidarity with us. And the 1st of March marked the first week of the full-scale invasion into Ukraine. And on the 1st of March, Ukraine exceeded the Council as an observer member, and now we have a possibility to organize our activities. Taking into account huge flows of migration of our citizens into Europe. We also received material support. These were donations through Red Cross, as well as support to Ukrainian families, families of notaries. And these funds are controlled by the Council, and these funds are spent only for support to the notaries' families when it is necessary. I would like to emphasize that these funds were collected transparently, and transparent dialogue with Ukraine was ensured in its meetings. And we would like to thank KNU for its efforts during the war to help Ukraine. Colleagues from France were the first ones to approach us, and we exchanged experiences. We deepened our knowledge in terms of digitization. We received specific practical support in this respect. In order to improve Ukrainian notaries' knowledge in the area of refugees, we organized 2 visits of colleagues from Germany to Ukraine, and a remote seminar was held, and we had similar activities with the colleagues from Poland. In response to the second question, what support is required by Ukraine? In order to have a successful reform, we need methodological assistance from the colleagues from the EU, and we would like to exchange expertise and insights. We also need consultations on adopting legislation on the Notariat. We also need assistance related to IT solutions and digitization. In order to perform these processes in line with the EU standards, we have to digitize our archives, and we also want to put in line the main Ukrainian registers with the EU registers, align them. And we also want to provide assistance to the citizens already residing in the EU. To conclude, I would like to express my sincere gratitude to Mr. Marius, who, as well as other colleagues from Lithuania, all Lithuanian notaries, for excellent organization of this event and continuous activity and support to the Ukrainian Notariat. These words are very important, and they are not just words. And I told Marius that if Lithuania was of the size of the US, we would have won the war already in 2022. Thank you very much for your assistance and support, and glory to Ukraine. Thank you, President, for these beautiful words, for telling about the Notariat and its functioning during the war. And now I would like to give the floor to Nicolas de Bodes de Fransur, who is the president of the Commission for European Affairs of the French High Council of Notaries. He will give a presentation on the digital tools at the service of the notary as a play and the rule of law and the state of play in 2024 and prospects for the future.
Monsieur le Président, Mesdames et Messieurs les
Dear President, ladies and gentlemen, dear colleagues, guests, first of all, thank you very much for the honor of speaking to you today in Vilnius during this conference. I hope that I will be able to finish my presentation because I've lost my voice a little bit, but let me start. So, first of all, speaking on the subject of the notariat and the rule of law is an obligation. The subject is far from neutral. It poses questions as to the very essence of our professional practice. The rule of law is, of course, a concept that is part of continuity. Nothing is static. Everything evolves with time. What questions did our predecessors ask themselves? How did they put it into practice? And what about today? In 2011, the Council of Europe's Venice Commission worked on a definition of the rule of law and concluded that it was impossible to define it strictly. It did, however, draw up a list of fundamental elements that are necessary for a state to be governed by the rule of law: legality, legal certainty, prevention of abuse of power, equality before law and non-discrimination, and I'll go back to this, access to justice. So, through their various tasks and responsibilities, notaries contribute to the rule of law on a daily basis. Notaries put the will of the parties before them into a form that complies with the law. They are those who guarantee the legality of contracts. They also ensure legal certainty because the parties come to notary because they're looking for authenticity. With him, the parties have the almost certainty that their deed will not be contested. The notary is a gateway to justice. Notaries' offices are spread throughout the country so that everyone has easy access to a notary. Notaries are independent, autonomous in their office. They do not receive instructions from politicians. They strictly execute the law. Nor notaries are paid by the state. Notaries are a liberal professional. They recruit the employees they want. So I was asked to talk about notaries and the digital tools they use and what is waiting in the future. So digital technologies are part of daily work for notaries, but they have to remain independent. We should not be dependent on commercial businesses because we would be vulnerable. So digital tools provide the opportunity to have access to information. New technologies are a tool because, first of all, we are notaries, and tools have to serve our needs, not vice versa. We shouldn't be adapting to the tools. Digital tools used daily in our work. We also use them in our personal and professional life, and every notary in Europe does that. Citizens have to have access to information because equality of citizens before the law requires access to information. No one is supposed to be ignorant of law. In France, in 1999, there was Légifrance established in France, and Internet users have free access to all legal texts still in force since 1539. At the European level, we have our Lex website, which provides access to all European Union law. We also have e-justice portal developed by the European Commission, which provide access to translated information on national laws of each member state. The notarial profession was involved in the drafting of several of its sections. The websites developed by CNU, which are well known here, such as Successions Europe, Couple Europe, and others. And this ensures access to information to our colleagues, citizens, other legal professionals. Notaries use tools and services developed directly by structures within the profession, by private service providers, or by government departments. In France, we have set up a structure, the Superior Council of Notaries, which is our national body. It is crucial for us to have this to ensure digital sovereignty. Digital tools are a tool for a notary, and this digital sovereignty relates to the essentials, the notary's main working tool and its long-term hosting. I'm talking, of course, about electronic authentic instruments. For the essentials, we must have our own staff, we must control our own technologies, we must not depend on the investments or economic or political choices of others. The structure that gives us our digital sovereignty is called ADSN, Association pour le développement du service Notariat. So this is Association for the Development of the Notariat. It is an association established under the law of 1901. This means that profits are not redistributed. Everything stays aside the association. The governance is run by notaries. ADSN employs around 250 people. So there are around 50 people working for the group. Other European notaries have also chosen to distinguish digital activities from the traditional activities of the bodies that organize the profession and represent it to the public authorities. I am thinking in particular of Notariat in Germany, Ansert in Spain, and Notartel in Italy. We have a digital strategy that guides our actions, and it was adopted at the digital meeting of the Council Supérieur du Notariat in France. For the last 20 years or so, digital notarial services have been organized around three strong pillars from the basis of our main working tool, the authentic instrument in electronic form. So three main pillars are the notarial digital identity and the qualified electronic signature, closed network, which is the communication channel with the notarial sphere, a central registry that is the single storage space for authentic instruments on electronic media. In our country, citizens do not yet have a standardized electronic signature tool. Individuals and businesses that need one use private service providers. We would therefore need to issue a digital identity identity to people working in the notary's office. Our closed network enables notaries to communicate with each other and exchange documents with the French authorities. The central registry is a gigantic server we have. The main server is located in Provence, and replicas are stored in secret locations. The central registry currently stores more than 32 million records. These include all types of deed sales, donations, marriage contracts, successions, authenticated leases. So these are three pillars that have enabled us to develop the main working tool for notaries, the electronic authentic instrument. And this instrument has been in service since 2008. With this instrument, the original is always the digital file. The documents printed out for clients are just copies. It comes in three forms: authentic deed in electronic form signed at a single notary's office. The notary uses his signature key and client sign using a pen on a touch sensitive tablet. Authentic deed signed electronically at two notaries' office. Our country, France, is very large and family members often live more than 500 kilometers apart. The two notaries organize a video conference and the draft deed is displayed in both offices. And for one or another reason, if people cannot come to a single notary office, we can use two notaries' offices. The notaries present alongside the client sign with their respective keys, while the client sign with, again, a pen on a touch-sensitive tablet. Authentic electronic power of attorney signed in remote appearance is also a tool. This is method primarily intended for clients who are a long way from the office, abroad, for example, or for clients who, because of their disability or other reasons, have difficulty traveling. The notary signs with his key again. For clients, we use a private online identity verification service. Effectively combating money laundering and the financing of terrorism is part of our role as a player in the rule of law. To this end, we use various digital tools to help us assess the risks. If the register of beneficial owners maintained by the Institut National de la Propriété Industrielle enables notaries to check the qualities of the parties to the deed. We use digital technology to keep abreast of the latest developments in real time and also to train ourselves and our staff. We have developed various e-learning tools. We took a close look at the possibilities offered by blockchains. We came to the conclusion that they were expensive, energy consuming, and did not provide a better service than we currently use. So for artificial intelligence, on the other hand, we have found two concrete uses: efficiently classifying documents in complex property files, making extended search proposal in the register of wills using surname with close spelling. So this is how we use AI. The French Notariat has a number of priorities for the future. So first priority is the future European digital portfolio introduced by the European regulation of April 11th, 2024. Each member state will have to propose one or more European digital portfolios. The digital wallet will be a digital identity tool and will contain various attributes for notaries. There are several issues at stake. So recognizing each other among notaries, thanks to the attributes that justify their professional status. Using this digital identity to ensure the identity of our customers. So digital technology will be a real factor in legal security, fewer errors, the ability to represent a person effectively in the digital world, and above all, less risk of identity theft. Second, training in artificial intelligence. So talking about artificial intelligence in the notarial profession is a good thing. Understanding and using artificial intelligence correctly is even better. To do that, however, you need training. AI sometimes gives incomplete or incorrect answers. The regulator give different answers to different people asking the same question. So it is very likely that if 10 of you were to ask the same generative AI tool, to use the same generative AI tool, each in their own way, why the 11th person who asked the same question will be told a very different answer to the first 10 answers. Let's not forget that our clients are mobile. People use different countries to live in their different stages of life, and we have cases where Ukrainians have to leave their country and they live now in a different country, and wills are concluded in one country but the end of life happens in a different country. So we need to be very vigilant. We need French notaries actually encourage to unify all the registers that we have across the EU regarding wills. So only 13 registers of wills and 4 registers of European certificates of succession are interconnected. There should be many more. So being able to find a will, being able to find a European certificate of succession is important. These are key elements in guaranteeing that the succession runs smoothly, limiting conflicts within the family. So the French Notariat is calling for all the European registries of the wills and successions of the CNU notariates to be interconnected as soon as possible. There are political, administrative, and technical obstacles, of course, but in reality, nothing is insurmountable as they can be overcome. So since 1957 and the signing of the Treaty of Rome, much more complex obstacles have been overcome. Let's not lose sight of that. Today, the notariate profession uses data from government departments, clients. It produces data that is communicated to government departments and third parties. For example, we work closely with INSEE, the French National Institute for Statistics and Economic Studies, to produce property statistics. We will be working on more rational approaches to ensure data flows more smoothly and securely. In future, data will be more secure and better stored. The data will also be better used. There's nothing coincidental. In France, we'll be in November. We'll be having a forum dedicated for digital security that will contribute to our use of digital tools. And let me go back to the rule of law can only be ensured when the interests of the most vulnerable in society are protected. The weakest and the protection of weakest is most important. The weakest include, of course, people who are disabled, senior citizens, those who are economically and culturally vulnerable. Notaries generally know these groups fairly well. They're known to us, but I'd like to spend a few minutes with another group, talking about another group of people, those with invisible disabilities. The best known of these is autism. As we know, there are several forms of autism. With mental disability, without. The customers concerned and their families have specific questions and their needs have to be addressed. So how can we make sure that the autistic person has understood everything about the act to which they are committed to, if there has an autism spectrum disorder? So in the French notarial profession, along with several of my colleagues, I'm leading the Nautism project. This project includes a digital component. We intend to put modules on the Real portal, the intranet of French notaries and their colleagues, to help them diagnose the situation, both in legal terms and in terms of social aid, and to help notaries recommend the right decisions. The models will be on the Real intranet, as I've mentioned. So everyone, French notaries and colleagues, will be able to see the situation. These modules will help or will assist notaries in making the right decisions. Decisions as to what assistance needs to be provided to a person with autism, for example, or what strategies a notary should employ. Digital technologies are an important topic, and we see that this is a very useful tool in our works because notaries has to be at the heart of public interest, and this is one of the raison d'etre of notaries. Thank you very much. Thank you for your insights, Chairman. Right now, I would like to invite Jans Bormann. Unfortunately, Professor Jans Bormann is unable to attend the conference. He made a recording of his presentation, Rule of Law in Times of Crisis and Uncertainty.
Dear President, Stratskaitis, dear Marius, distinguished speakers and guests, ladies and gentlemen, dear colleagues and friends. It is an honor and a pleasure to speak to you today about a subject of profound importance, the rule of law in times of crisis and uncertainty. For the next few minutes, I'm first going to address the relevance that the rule of law plays for the state, the society, and the economy, and what role notaries play in preserving it. Next, I will address current challenges to the rule of law and the reasons that make it essential to preserve it, particularly in times of crisis and uncertainty. So why is the rule of law so important? Because it is fundamental to the stability and prosperity of the state, the society, and the economy. For the state, it guarantees legal certainty by ensuring that laws are applied consistently and fairly, preventing the arbitrary use of power and safeguarding human rights and democracy. In society, the rule of law fosters trust in institutions and social cohesion by ensuring justice, protecting individual freedoms, and maintaining public order. Economically, it provides a predictable environment for businesses, encourage investments and economic growth by protecting property rights, enforcing contracts, and reducing corruption. Therefore, the rule of law is essential for maintaining a just and functional society where individuals and institutions can prosper and thrive. The Notariat as an institution plays a pivotal role in preserving the rule of law. It serves as a bridge between the state's legal framework and the citizens who rely on it for protection, fairness, and the assurance that their rights will be respected. In this process, a notary is much more than an independent holder of a public office. He or she is in fact a guardian of legality, a protector of rights, and a guarantor of freedom. Whether it is the authentication of a contract, a last will, or a power of attorney, the involvement of a notary ensures that these acts are carried out accurately, in a legally sound manner, and compliant with existing regulations. Thereby, notaries help to reduce the potential for conflict and litigation by preventing disputes before they even arise. This counteracts arbitrariness, provides legal certainty and peace, and therefore leads to freedom. This role as an ex-ante judge is an indispensable cornerstone of European continental legal systems. Notaries also guarantee public trust. In a world where legal transactions are increasingly complex, notaries ensure that the legal process is transparent, reliable, and trustworthy. By acting as an impartial public official who thoroughly informs and advises the parties and who ensures that they act of their own free will. Notaries de-bias the contracting parties and equalize the bargaining power. However, despite its importance, the rule of law cannot and should not be taken for granted. It can come under pressure, as is currently the case in Ukraine. This is on the one hand due to the war that Ukraine has to endure, and on the other hand due to the need for transformation that is being hampered. The war in Ukraine has been a severe challenge for the preventive administration of justice. If we take the notarial profession as an example, many Ukrainian notaries have been injured or died. After the invasion, only around 2,500 of originally 6,600 notaries were in office. As a result, it was more than difficult for citizens to get access to justice, and the state was missing its trusted partners and reliable gatekeepers. This is bad enough in otherwise stable circumstances, but impairments of the rule of law in times of crisis and uncertainties, like war, bring along a further problem. In such times, citizens, the state and the economy more than ever need a stable legal framework for proper governance and decision-making to avoid a heightened risk of arbitrariness and undermining of the democratic process. To prevent an erosion of individual freedoms and to enjoy safeguards against the imposition of unchecked power, we need to be able to rely on the rule of law as it will allow us to strike the right balance between an effective crisis management and the protection of civil liberties. Moreover, being able to rely on the rule of law in times of uncertainty will foster public trust. When citizens see that laws are applied consistently and fairly, even during a state of emergency, this reinforces the people's confidence in institutions and the government's commitment to justice and equality. This trust is essential for social cohesion. Thereby, a crisis can be navigated through with a sense of order and fairness, ensuring that all actions taken are not only effective, but can also be justified and are transparent. Fortunately, our Ukrainian colleagues proved to be exceptionally resilient, and towards the fall of last year, 4,000 colleagues were back in office and could work again to serve the Ukrainian citizens. Despite these unique challenges, including disruptions of notarial operations, threats to personal safety, and difficulties in accessing official records, our Ukrainian colleagues have continued to provide public services, and this is really outstanding. For example, to ensure that citizens have this continued access to justice, our Ukrainian notaries published lists of notarial offices that remained open. Additionally, they have shown incredible levels of collegiality. Ukrainian notaries are financially supporting colleagues who are currently not able or capable to perform in their offices. A support that is not limited to colleagues, but also extends to families of notaries who have passed away. Finally, under great personal danger to health, life, and liberty, the notaries in Ukraine even continue to provide public services in areas of immediate active war. They make sure that crucial and important legal transactions, such as last wills, certificates of inheritance, powers of attorney, or custody declarations, can be authenticated even in the front line. These efforts of our Ukrainian notaries to honor their role as guardians of legality, protectors of rights, guarantors of trust, and securers of freedom is a true inspiration for all of us in Europe. I can only praise our colleagues in Ukraine for these remarkable accomplishments, despite the incredible challenges that they face on a daily basis. Their dedication and motivation should be an example to guide us in our future endeavors to support Ukraine. On top of these challenges, in the everyday work comes a challenge we are all facing: the need for digital transformation. The current situation has made it more difficult to modernize the notarial profession, including the strive for digitalization of its procedures in Ukraine. At the same time, adapting and updating notarial procedures to provide for the needs of a more digitalized world will be inevitable. The great push for digitalization can be seen everywhere, especially in the heart of Europe. The European Commission launched an ambitious program for a digital decade, leading to the European institutions passing many legal acts aimed at ensuring a greater extent of digitalization of the judicial system. These legislative efforts will also have a substantial effect on the notarial profession. To name a few, the European institutions introduced already in 2019 the first Digital Tools Directive that provided for the online formation of limited liability companies. There will soon be a European digital identity wallet with an eID and attributes, allowing citizens and businesses to identify themselves and prove other personal attributes by digital means. Further, the cross-border communication between public authorities will soon have to take place digitally in accordance with the new e-justice regulation. Of course, these new requirements may seem like very difficult tasks. They force us to think outside the box and to some extent reinvent our own profession. However, these challenges can also be turned into opportunities. They can strengthen the notarial profession by urging us to preserve our well-served procedures and safeguards of the past and transpose them into a bright future. Speaking of a bright future of the notaries in Ukraine, how do we get there and how can we as notaries help? In fact, notaries play an essential role if we do our job. Citizens and businesses can trust that their transactions are legal and secure. This makes them more likely to engage in economic activities, invest in property, and support the broader economy. As public officers and gatekeepers for land and commercial registers, notaries are essential in rebuilding and maintaining a functioning register system that can be endowed with public trust. For one, this trust is not only critical for the internal stability of a country, but also for its reputation on the international stage. In addition, a reliable register system is the first line of defense against corruption and money laundering. Finally, we have seen over and over again that the notarial profession has the potential to be a digital frontrunner. By embracing digitalization, notaries can not only enhance their public services, but also lead broader digital transformation of the legal sector. This is not just a matter of convenience, it is a necessity for timely and efficient reconstruction in times of war and uncertainty. A modern, digitalized legal system will streamline processes, reduce the potential for illegal activities, and make legal services more accessible to all citizens, even in the most remote areas. This digital leadership will be a significant contribution to the rebuilding efforts, ensuring that the system of preventive administration of justice in Ukraine is not only resilient, but also forward-looking. Taking into account the situation in Ukraine, all of these efforts, legal certainty, reliable registers, and digitalization, are crucial for the rebuilding of the Ukrainian society and economy. In a nutshell, the work of notaries is fundamental to the rebuilding of the situation in Ukraine, of the society, the economy, and the future. Then again, we cannot and will not let the Ukrainian notaries face these tasks and challenges alone. This is why our umbrella associations, the Council of Notaries of the European Union, as well as the International Union of Notaries, have been looking for ways to support our Ukrainian colleagues. At the same time, we must acknowledge that the punctual and isolated support will not be sufficient to achieve this goal. Ukraine requires not only short-term aid, but also a comprehensive and sustained effort, what I would call a modern-day Marshall Plan. This Marshall Plan must be a broad, strategic, and public assistance program dedicated to the support of Ukraine's preventive administration of justice, with a particular focus on revitalizing the notarial system. The Council of the Notaries of the European Union is in the process of preparing a concept note which will outline the specific knowledge, expertise, and support that European notaries can offer. This document will also detail the types of assistance that are most urgently needed on the ground. Let me offer a few examples of the specific proposals we are considering. First, the reconstruction of notarial offices and the provision of essential office equipment are of utmost importance. As already mentioned, many notarial offices have been damaged or destroyed, and essential equipment, furniture, computers, printers, has been lost. Without these basic tools, notaries cannot perform their crucial functions. We therefore propose material support to help rebuilding these offices and supplying them with the necessary equipment, enabling notaries to resume their work and contribute to the legal and economic recovery of their community. Second, financial support for notaries and their staff is critical. Notaries rely on a functioning economy to generate the fees that sustain their operations. However, in times of war, the economy suffers greatly. In addition, the provision of public notarial services is severely limited in areas affected by active fighting. Third, Ukraine will need changes in the legal frameworks that allow for the implementation of digital tools in the notarial sphere. An example could be the implementation of an electronic archiving system. Especially in times of war, it can be challenging to safely store important documents. There has already been a concept note for an e-notary system. Based on this, notarial authentic instruments would be stored digitally instead of in paper. At the same time, in this process of transformation, it has to be ensured that the safeguards and protections of the analog world are also transferred into the digital sphere. There's no sacrifices to legal certainty and the rule of law. This would mean that an electronic archive will have to adhere to the highest security standards regarding access, confidentiality, and data storage. In conclusion, strengthening the rule of law will ensure that rights are protected, legal certainty is maintained, and justice is preserved. It is a task that requires vision, determination, and collaboration, attributes that our Ukrainian colleagues have shown and will surely show in future in the post-war reconstruction process. I'm certain that with notarial involvement, a functioning administration of justice can be rebuilt for the better of citizens and businesses in Ukraine. We, as Bundesnotarkammer, the Federal Council of German Notaries, as well as the Union of International Notaries and the Council of Notaries of the European Union, will continue to support our Ukrainian colleagues. In this endeavor, we are also counting on the support of the European institutions to help us translate this idea of a Marshall Plan from concept into reality. And I'm sure that today's conference will be a great step in the right direction. I wish you all a successful conference with lots of insightful interventions and discussions. And I'm looking forward to a bright future for European and especially Ukrainian notaries. Thank you very much for your attention.
Let me invite Dr. Yana Kolomets, assistant of the Department of Civil Justice and Advocacy of the Yaroslav Mudry National Law University of Kharkiv. She'll be talking about the rule of law and challenges for Ukrainian notaries in the times of war.
Hello, dear colleagues. I'm glad to be here and speak in front of such esteemed audience. First of all, I'd like to thank all present and all the people of Lithuania for the support Ukraine. It's what's very important and exciting for us. I'd like to thank the Chamber of Notaries of Lithuanian for the invitation. I feel a great responsibility to speak before you. Today, I'm here to talk about the rule of law and challenging for Ukrainian notaries and the condition of war. We know that the concept of the rule of law, along with democracy and human rights, make up the three pillars of the Council of Europe. Of course, these elements are important for every country member of the Council of Europe. A fundamental aspect of the rule of law is the public trust in the legal system. When individuals believe that laws are fair, transparent, and consistently applied, they are more likely to comply with them, and as a result, they don't seek legal research so often. Notarials serve as essential subject in the legal system, ensuring that notarial acts are conducted in a manner that are clear and accordance with the law. The ongoing conflict in Ukraine, particularly following Russia's full-scale invasion in February 2022, has significantly disrupted the country's legal and administrative system. War is vastly different from peaceful life. Theoretically, it can be imagined, but in practice, it cannot. But the legal, democratic, and constitutional state must ensure the protection of human rights even during the war. Therefore, the notarial system, which plays an extremely important role in safeguarding and protecting human rights, must continue to function. And today, the notarial system in Ukraine is indeed operational. By the way, we should thank our foreign partners, who is actively participating in ensuring the condition operation of notarial system under these incredible circumstances. During the war, we faced challenges that were previously unimaginable. This includes damage to notarial offices, damage and destruction of notarial cases and archives, power outage, lack of access to electronic registry, and the inability of notaries to work because they were forced to leave their homes to protect their family or found themselves in active combat zone or even in invaded territories. Constant missile strike across the country pose a real threat to everyone within Ukraine. Today, we face far more issues and challenges than other countries, it's my opinion, and we must resolve them, which we are starting to do. A bit about the measure taken in the first day of the full-scale invasion in February-March 2022. Several steps were taken, a simplified certain procedure to ensure that the notarial system continue to function properly and uphold citizen rights. For example, wills, powers of attorney, and the certificates of signatures on documents could be done not on special notarial forms, but on plain paper. Certain provisions were made for establishing a citizen identity using expired documents. Some procedure deadlines were suspended, among other measures. Of course, the introduction of such simplified procedure was only temporary. It was the unusual reaction to the critical situation in the country. However, the notarial process always requires strict adherence to procedure. By following strict procedural standards, notaries help prevent fraud, protect the legitimate rights of all parties involved, and strengthen the overall integrity of the legal system. Therefore, any simplification of procedure are only possible to the extent that they do not affect the legality of the Notarial Act. Such simplification are permissible only expiration allowable cases. What measures or legal reforms should be implemented to ensure the notarial system continues to operate effectively under such conditions, supporting and strengthening the rule of law, which is cornerstone of a just and orderly society? One of the steps should be the continued active implementation of electronic notarial services. Of course, this is a new idea today. Vera Bondarenko, Volodymyr Valchenko spoke about it today. It's important to note the electronic notarial services are already in operation today in Ukraine at a certain level. Today, notaries regularly use electronic register in their work and have the ability to obtain the necessary information for performing notarial acts in electronic format. Currently, notaries in their work use then 15 electronic register and have access to over 20 electronic researches. Of course, this is the beginner, and work is also ongoing to implement an electronic notarial archive and transfunction fully to electronic records management along paper records. Especially since such successful electronic notaries particularly already exist among our partners, Lithuania, Germany, France, and some other countries, and we would like to adopt this experience. However, even if electronic notarial services in Ukraine were to operate in full capacity today, as we desire, it still would not ensure the stable operation of notarial system as before, because the country's energy system is constantly targets the Russian attacks. And electronic notary doesn't work without electricity, of course. We are currently seeing certain issues faced by our citizens who have gone abroad to the war. However, unlike the electronic court, which can provide access to judicial services for individuals even outside the country, the electronic notary today does not help resolve problems related to often essential actions such as the power of attorney, inheritance rights, and more. This concerns not only Ukrainian, but also many people who are outside their own country, they can't do it. It is perhaps without our power to solve such problem after all. My proposal for strengthening the rule of law is to create a unified standard for performing specific notarial acts with a single form for the notarial acts documents. This would allow this notarial act to be used abroad without additional procedure for apostille or legislation in all countries where such a standards is accepted. People's needs are generally similar. Drafting wills, using powers of attorney, donated property, satisfy signatures, and so on. In general, the scope, the procedure for performing such notarial acts in different countries are similar because we belong to the Latino notarial system. However, we cannot present a notarial document such as a power of attorney satisfied by a foreign notarious authority in our country without the additional procedure of legislation, apostille, or translation. This applies to the measure of notarial acts. For lawyers and notaries, such procedure seems straightforward and simple, but for ordinary person, they represented additional time, money, and certain complications. Therefore, I propose creating a certain standard form for a notarial act that is consistent and ensure scope and procedure and can be used without additional apostille legislation or translation in different countries. This should be a certain establishment form in which the essence and content do not change, where the notary enters the necessary information and the will of the applicant and duly satisfied is. Of course, it would be convenient for this to be a bilingual form with one of the language being international language, for example, English. Such form should be identical in all countries, with the content of the Notarial Act present in international legislation and the legislation of the country. It is also possible to provide for the use of certain abbreviation in such a form to indicate the main or additional conditions. The meaning of this abbreviation should have the same content in all countries, similar to how Incoterm rules are used today. The creation of such standards for Notarial Act would eliminate the need for apostille documents, legislation, translation, without questioning the legality of the act itself and the documents. The main idea is to create and develop Notarial Act for international use without additional procedure in the future. Certainly, the establishment of such standards should be accompanied by a legislative framework so that such notarial acts for international use are recognized and accepted not only with the notarial community, but also by a government institution. If we continue to develop the topic of creating standards for notarial acts for international use, it is also necessary to talk about creating international researchers for such notarial acts. And if we think a few steps ahead, it is necessary to provide for the possibility of using a notarial act in electronic form, where performing such notarial act. Since this is notarial act for international use, the verification of its authenticity and accuracy in the country of consumption will be thorough to protect any fraud. The availability of an electronic notarial act will significantly simplify the procedure, since additional security measures can be established for electronic documents, such as an electronic digital signature, document verification, and more. This means we are moving towards international notarial acts. Of course, the number of such notarial acts should be limited at the beginning. Perhaps this idea might seem rather unusual, but on the other hand, the modern notarial system has already been moving toward active international interaction. Since 2005, the European network of Register of Will Association has exciting. Today already has 21 member countries. For 15 years, the European Notarial Network has also been in existence. Today, the ENN connects notarial without the UA and provides a forum for transnational professional exchanges. It provides information on the law of all member notaries, including real estate law, family law, succession law, and company law. In addition, it offers the possibility to contact colleagues in other countries directly with questions on foreign law. In the past year, the ENN has been particularly active in providing legal assistance to Ukraine. For example, the ENN collected a large amount of specialized information on Ukrainian law and made it available to colleagues in the UN member states. The UN also makes bilingual form available for download free of charge, will enable parents to express their wishes regarding the journey of the child living in Ukraine, the exercise of parental responsibility. These forms, developed within the UN, show the real demand for the creating notarial act for international use that can be used by the population in different countries without additional procedure. The very possibility of creating such notarious act highlights the significant role notaries play in the legal system. In summary, I would like to say that despite the challenges, the Ukrainian notary system continued to function, ensuring the protection of citizen rights through its request adaptation to new conditions. And today, that our country to develop rapidly and the notary system is keeping pace. Such concepts as electronic notaries, electronic archives, and remote notarial services are no longer the future, but our present. The high migration of people between countries has revealed a real need for the certain of notarial acts for international use that can be used in different countries without additional procedure. This message will also contribute to strengthening the rule of law by ensuring the legal certainty of notarial acts beyond the country's border without additional procedure. Thank you.
Ačiū pranešėjai.
I thank the speaker. Today, we have already heard a lot of valuable presentations about the rule of law and notariats, and my presentation will be about the notariat. I will try to answer the question of what a strong notariat needs, which, despite the war in the country, is discussing with the Ministry of Justice amendments to the notarial law that would make the Ukrainian notariat even stronger. Having analyzed the proposed amendments and taking into account the core values of the Latin notariat and the experience of the notariats in the European Union, I would like to offer my insights. The first important element is the status of the notary. Currently, notarial acts in Ukraine are performed by notaries working in state, in public notary offices, or engage in private notarial activities. Although the powers of private and public notaries to perform notarial acts and the legal force of the documents they draw up were unified in 2008, the dual system of notaries remain. This creates a bad situation where the notaries which work independently are in worse situation than those working in public notaries. So the number of notaries of public notaries is governed by the state, and the number of private notaries is not. And this means that the state competes with the private sector. In the amendment, it is proposed to move forward a single private notariat, and this amendment is, in my opinion, very important and necessary. In the Latin notariat countries, the notary performs public functions delegated by the state, but organize their work independently as a member of the liberal profession. The system of private notaries is more efficient than that of public notaries who are civil servants. Private notaries as agents of the state compete with each other on the quality of their services in order to attract more clients. In order to have more clients, private notaries have to ensure high quality of notarial acts and services. The abolition of public notaries would reduce the number of civil servants and the budgetary cost of maintaining them. The interest of private notaries in the quantity and quality of notarial acts performed, as well as the personal civil liability of the notary, would help to avoid corruption. Another important point is that notarial acts should be carried out by persons who are properly trained to do so. The International Union of Notaries requires that notaries as professionals obtain the maximum legal qualification in order to practice law in their respective countries, meaning that they have to pass the examinations that entitle them to practice the profession and have the necessary legal knowledge to be able to effectively and accurately verify the legality of the deeds and documents they prepare. In Ukraine, notarial acts can be performed not only by notaries and consular officers, but also by officials of local self-government bodies. These provisions are not proposed to be changed in the draft amendment to the law on notariats under consideration. We are convinced that only notaries who have passed an examination, who are constantly improving their professional skills, and who are under the control of the Chamber of Notaries and the Ministry of Justice can perform notarial acts competently. No other persons, neither assistants to notaries nor employees of the notary's office, nor officials of local self-government institutions should perform notarial acts. The State Audit Office of the Republic of Lithuania, having carried out the audit whether the effective performance of these functions entrusted to bailiffs and notaries is ensured, also pointed out that there are no qualification requirements for local self-government officials to perform notarial acts, no provisions on who should organize their training and how, and no supervision of notarial acts performed by local self-government officials. I would like to say that it is impossible and ineffective to establish uniform qualification, training, and supervision requirements for persons for whom the performance of notarial acts is only an auxiliary activity. When notarial acts are carried out by persons who are not properly qualified, their quality cannot be ensured and clients may suffer as a result. The need for other persons to carry out notarial acts is also reduced by remote notarial acts. A person can then choose any notary working in the country and is not limited by their liability. Therefore, I believe that the draft amendment to the law on notariats of Ukraine should be supplemented by stipulating that notarial acts are performed only by notaries and consular officials. This would ensure that everyone follows the same rules for performing notarial acts, have the same training, are subject to the same supervision of notarial activities, and are subject to the same professional civil liability. This would ensure the quality of the notarial document and the stability of civil legal relations. Another important element of a strong notariat is professional self-regulation. Notaries are united by a single organization composed exclusively of notaries, which is independent of the state, but in line with the principles of public law and recognized by law. The draft amendment to the law on notaries of Ukraine, or Ukrainian Notariat, proposes to move towards self-regulation of the notarial profession and to transfer part of the powers and social responsibility in the field of notarial work from the executive power to the self-governing body of notarians. This change is welcome. Professional organizations of notaries have easy access to the information they need to regulate. They spread the costs of regulation among their members, and they react quickly to changing situations. Unlike regulation by public authorities or by an independent body established by the state, self-regulation is not only more effective, but also has no cost to the state. Among other functions, the professional organization of notaries may be entrusted with the supervision of notaries' activities by carrying out routine inspections of the notaries' activities, while the Ministry of Justice retains the right to carry out inspections of notaries' activities based on complaints of individuals. The supervision of the activities of the notary self-governing body by the Ministry of Justice consists in the right to appeal against the adopted decisions to the court, but the Minister of Justice cannot take any other measures. For example, convene extraordinary meeting of the notaries and similar things. The public nature of the notary's functions leads to strict regulation of the notarial profession. In order to ensure public control of the profession and the quality of services in the countries of the Latin Notariat, notaries usually have a monopoly on the performance of certain specific functions. That means that notarial functions are assigned only to notaries, while other elements of competition that may influence the proper performance of functions, such as number of notaries, remuneration levels of notaries, are limited. The state determines the number of notaries which must meet the needs of the population, but at the same time ensure the economic independence of the notary. The state also usually sets the remuneration of notaries. For example, the law on the Lithuanian Notariat establishes the following criteria for the determination of notaries' remuneration rates: the value of the transaction or other notarial act being certified, the nature of the notarial act or service being performed, ensuring economic independence of notaries, notaries' professional and civil liability risks, cross-subsidies, and costs. Taking into account these criteria, the government of the Republic of Lithuania determines the remuneration of notaries in accordance with the methodology it approved. And as of the 1st of October last year, all remuneration rates for notaries in Lithuania are fixed. Although the Notariat is a tradition-fostering community, the electronicization and digitization that has reached all fields, all the areas, is also very important for the Notariat. And all the speakers today mentioned that. The draft amendment to the law of the Ukrainian Notariat provides for the creation of an electronic notarial system. An electronic system ensures data integrity. It facilitates the preparation, storage, and retrieval of data and documents. Obtaining statistical data on notarial acts would need much less time. The system could later be used for remote notarial acts. And electronic notary's workplace would make the notary's work more efficient, of higher quality, and quicker. The draft amendment to the law on the Ukrainian Notariat provides for 3 bodies responsible for the electronic notarial system: the Ministry of Justice, the owner of the system, as well as technical and functional administrators. To my mind, there is a risk of cooperation problems between these 3 institutions. The changes needed by the Notariat may not be implemented as quickly as would be desired, as the 3 institutions will need to be coordinated, and the technical administrator will need to incorporate them into their working plans. I can share my experience. The e-Notara system was created by the Chamber of Notaries at their own expense and is managed by them. Since the 1st of July 2021, the notarial acts are performed remotely in the e-Notara system. As statistics shows, this way of performing notarial acts is becoming more and more popular. In July this year, almost 10% of all notarial acts were performed remotely. It is up to us to decide what improvements to the system are needed and when they should be implemented. It seems to me that the development of this system will require a lot of money, but it will allow the notaries and their clients to have a convenient system. I have looked at just a few aspects that are important for every notary. The Lithuanian Chamber of Notaries has been cooperating with the Ukrainian Chamber of Notaries for a long time, and the Council of Notaries of the European Union and individual notaries belonging to the Council of Notaries of the European Union provide their support. I would like to say once again to our colleagues from Ukraine, we will help in any way we can. If you need any help with the draft amendments to the law on the Notariat, implementation of digitization projects, or any other areas, please do not hesitate to contact us. I am certain that only when united we can help Ukraine. I thank everyone who participated in the events of the Lithuanian Presidency of the Council of Notaries of the European Union in 2024. I thank you for your participation. I thank the interpreters for their work. I invite you all to lunch prepared for you in the nearby Grand Duke's Ball. Thank you very much.
Від імені нотаріусів України, всієї України, хочемо вам подякувати.
On behalf of the notaries of Ukraine, I want to extend my gratitude to you and use the symbol as appreciation. The symbol is rather heavy. You can use it for protection as well. Hopefully, after we win this war, you will look at the statue and will remember how much has been done together in order to achieve the victory, how much has been done not only by notaries, but by everyone across the world. Thank you very much once again.